Welcome to the Minneapolis Rental Screening Ordinance Forum, presented by the Minnesota Multi-Housing Association, or MHA. My name is Aubrey Albrecht, and I'm the Vice President of Education and Chief Innovation Officer at MHA. First, I want to take the time to thank our sponsors, Assured Security, Cozen O'Connor, Foss Choles Agency, and First Select Property Management. The generous contributions of our sponsors allow us to offer this timely resource to our members at no cost. Thank you very much for your support and your partnership. This webinar will be recorded and made available publicly on MHA's YouTube channel. The webinar is provided in order to assist rental property managers in compliance with the Minneapolis Rental Screening Ordinance and should not be viewed as an endorsement of the ordinance or any statements, opinions, or viewpoints concerning the ordinance. This webinar is provided for informational purposes only and is not legal guidance. You should consult your legal counsel for advice on legal matters. The views that will be expressed in the webinar are attributed to the individuals expressing them and do not necessarily represent the views of MHA, its members, board of directors, staff, or sponsors and participating companies. We have a great panel this morning, all of whom are on the City of Minneapolis's Cross-Sector Implementation Committee for Renter Screening and Security Deposit Ordinances. Our first panelist, Kelly Jones, has worked for the City of Minneapolis for over 30 years. In 2018, Kelly was appointed to the position of Director of Housing Inspection Services and oversees a staff of 45 people. Jennifer Spadini is the President and CEO of Guardian Property Management and Guardian Property Maintenance, who currently operates over 800 multifamily units. Jennifer is second vice chair and chair of the Municipal Affairs Committee for MHA. Lee Wolf has worked for the City of Minneapolis for over 21 years as an assistant city attorney, practicing for 9 years in the city attorney's office criminal division as a prosecutor, and for the last 12 in the department's civil division. Last but not least, Joe Abraham is a principal investor at Pergola Management, a local real estate firm that owns 750 market rate apartments in the Twin Cities. Joe is first vice chair and legislative chair for MHA. And with that, I will turn it over to Joe Abraham.
I just want to welcome everyone. We've got a really large group of attendees, and it's climbing by the minute here. So obviously a lot of interest in this, and hopefully we are able to answer a lot of your questions. I want to start, I'll state the date of the event. It's May 12th, 2020, and I'm just making sure that we have that on the record, because as this thing rolls along, as we interpret this over time, there's some likelihood that there could be different guidance and updates on what we were advising. And so I want to make sure that as we go back and look at this video, we got the date, we know when we're giving the particular guidance that we are. The other thing I want to make sure I do right away is I just want to acknowledge that there's a lot of people on here that probably feel strongly and disagree with the ordinance. So I just want to remind everyone that everyone that's in the call, in the forum today, is here to help us navigate this and provide some guidance and answer as many questions and make us as successful as we can as owners. To that end, I want to thank Kelly and Lee. Jennifer and I were on the cross-sector implementation team with them. They're going to do their best to try to help us serve the ultimate customer, the customers of ours, the residents of the city, and try to make sure that we understand all the ins and outs of this ordinance and give the best guidance that we can. There's a lot of others behind the scene, Christine Dowling, Katie Topinka, many others in the city that also helped us get here. They're not on the forum today. So what this is not today, I just want to make sure we're not going to sort of debate the efficacy of the ordinance, talk about alternatives, how we measure success. Not that those aren't important things, because I think they are. And I think it's important to acknowledge all this stuff before we get into answering questions. Because the real things, there's time and place for that. This just isn't that. This is not that time and place. You're going to hear a reference to a cross-sector team. I mentioned it. Kelly will mention as well. Jennifer Spadini and I filled 2 seats, invite seats on that. I was representing MHA. Jennifer was representing NARPM. The other thing I think it's important is to sort of acknowledge pieces of this, and you'll see as we go through it, there is some ambiguity in portions of the ordinance. We're here, we can't really provide legal advice. And as Aubrey mentioned, we'd highly recommend you seek legal review and counsel on this, but also counsel from your screening company. We will do our best. We will do our best to try to identify areas that are clear and some that are not so clear, so that you know sort of what's most important to focus your energy on. So I'm gonna hit 3. There's 3 goals objectives that we have today. 1, we want to go back, give a background, talk about the intent, and Kelly will review in detail what the ordinance says. The second thing is she'll review what the implementation or cross-sector implementation team was, what we've done so far, and resources that are still to come, and what we plan to do in the future. And the second thing, which I think is, for me, is the most important, and for many of you on this participating today, it's sort of differentiate between portions that are clear. I believe there are a lot of areas that are very clear, give specific direction, whether you like them or not, that's irrelevant. You know what the rules of the game are. And then I think it's important, almost as equally important as you understand which ones still need to be figured out here over time. And I think the market will figure those out. But I think it's important to identify those and address them head on. So I think that's our intent. Those are our 3 goals for the webinar today. Kelly Jones and Lee Wolf are going to take over now. They're from the city of Minneapolis. They'll walk you through the first goal here, which is to review the ordinances and talk about the intent. And then I'll be back a little later for questions and answers.
So hello, good morning, everyone. Thank you for joining us today. As everyone mentioned, my name is Kelly Jones. So I'm gonna go ahead and good morning, everyone. I'm Kelly, and I'm gonna go ahead and start the presentation here. If I can get my slides to work, which I can't. There we go.
Yeah,
So, yes.
I'm sorry, yeah, if you look in you see the bottom left corner of your screen, do you see the back and forth arrows? They should be really faint, but if you go over them, you might be able to see them.
Yeah, can everyone see the agenda?
Yep, yep, okay, that looks great, thanks.
All right, thank you. So quickly, as Joe mentioned, I'll talk about some of the background objectives of the ordinance itself, a little bit about the implementation of the ordinance and enforcement, and then the cross-sector committee. So some of the reasons for the creation of the ordinance are the fact that rental housing costs continue to rise at a faster rate than rental incomes. This is a barrier for renters, as high upfront costs can prevent obtaining rental housing. Many renters also have other issues that limit access to housing, for instance, poor rental history or criminal backgrounds. Also, historically, many low-income renters face barriers, racial discrimination in evictions and incarceration rates, and also access to credit score. And then finally, we want to acknowledge that this ordinance is consistent with other policies that are currently being adopted and considered by the city of Minneapolis, including the Minneapolis 2040 plan, which is the city's comprehensive plan, the Unified Housing Policy, which is a document required by HUD, the Renters First Policy, and the Strategic and Racial Equity Action Plan, which has a section on eviction prevention. So again, the ordinance, the screening ordinance and the security deposit cap fall in line with those other policies. So the first section I want to go over is the renter application screening. Again, the goal of this provision was to reduce barriers and increase access to housing. There are two main options. One is called the inclusive screening criteria. The other is the individualized assessment. Starting with the inclusive screening criteria, there are a couple of standards or parameters. One is criminal and eviction history. The other is a restriction on credit score. And the final one is rules on income to rent ratios. I also want to make it known that while using this option, you cannot be more restrictive, but you can be less restrictive. So there's nothing preventing that. So the criminal history section allows, indicates that you cannot screen out an applicant for things such as a conviction and an arrest in an inactive case, or an inactive case that did not result in a conviction, a conviction that's been vacated or expunged, the situation where an applicant has managed to comply with a stay, or participation in a diversion or judgment deferral program. Also, cannot consider conviction for a crime that's no longer illegal, or a conviction that happened while the applicant was in the juvenile justice system. The criminal history section goes on further to provide guidance on types of crimes and specific look-back requirements, starting with misdemeanors. So any conviction for misdemeanors older than 3 years old cannot be considered in a screening process. Criminal convictions for felony offenses where the date of sentencing are older than 7 years cannot be considered in a screening process. And then the ordinance calls out some specific violent felony offenses for which the dates of the sentencing are older than 10 years. And those include first-degree assault, first, second, third-degree murder, aggravated robbery, manslaughter, arson, kidnapping, and first-degree criminal sexual conduct. And you can see those on the screen. There are two exceptions in the inclusive screening criteria where an owner may deny an applicant, and those include a person who's been convicted of the illegal manufacture or distribution of a controlled substance, or offenses that automatically require denial in the federally assisted housing program or federally assisted housing programs, and that includes applicants who are subject to lifetime sex offender registration. The next provision in the inclusive screening criteria has to do with housing, background, and eviction history. So this section prohibits an owner from considering evictions that are older than 3 years old, or an action or a settlement older than 1 year old, eviction actions that were decided in favor of the applicant or that were dismissed, or if the applicant does not have sufficient rental history. The final section in the inclusive screening criteria has to do with credit and income history. So under the ordinance, you cannot use credit score alone to deny an applicant. You can, however, use credit history and information in a credit report if it's related to the applicant's ability to pay rent. If an owner requires an income that's more than 3 times the rent, then they must also allow the applicant an opportunity to provide information that demonstrates that they have a history of successful rent payment and can pay the rent in this situation. The second screening option is called individualized assessment. Essentially, if you're going to use screening criteria that's stricter than the inclusive criteria, you must review each applicant individually and consider any information called supplemental evidence that the applicant provides, which might explain or justify any information in their background screening that would lead one to deny them. In this situation, an owner must consider the nature and severity of the incidents, the amount of time that has gone by since the incident occurred, and the age of the individual at the time of the incident. So we've also included a couple of examples of supplemental materials that might be considered or a renter may supply. And that includes positive rental history and references, perhaps a letter from a probation officer encouraging the owner to provide housing. The rental certification completion, so if they took a renter's rights and responsibilities course and completed it, or a rental resume, which is a tool that our housing advocates support. So the last section of the ordinance I want to talk about is the cap on security deposits. Again, the goal of this section is to reduce the high upfront costs faced by some renters. So the first is that it caps security deposits at 1 month if you are charging a security deposit that's equal to or less than 1 month's rent. So example is the first month's rent is $1,000. The maximum security deposit in this situation could be $1,000 with a total upfront cost to the renter of $2,000. So if you charge more than 1 month's rent as a deposit, for example, first month and last month's rent, then the security deposit is capped at half month's rent. So in this example, again, first month's rent is $1,000, the last month's rent is $1,000, and in this case, the maximum security deposit could be $500. Also in this scenario or situation, the applicant is permitted to pay that security deposit in installments over a 3-month period of time. So I'm going to hand it off to Lee Wolf, who's going to talk about the enforcement and effective.
Thank you, Kelly. Lee Wolf with the City Attorney's Office. Just to do a brief discussion on the effective date and enforcement of the ordinance. The effective date for individuals that own properties or more than 15 units will be June 1st of 2020, while owners that own 15 units or less, the effective date will be December 1st, 2020. So they're given a little more time to come into compliance. So the way we anticipate the enforcement of this or these ordinances is most likely a complaint from an applicant who's been denied, most likely through Minneapolis 311. We also anticipate possibilities of, getting complaints from legal aid, Homeline, or some other tenant advocate groups coming to the city after they've talked to an applicant who's been denied. The way enforcement will go from there is the Department of Regulatory Services will assign a tenant navigator or investigator to investigate the claim, which means they will talk with both the applicant and the owner or property manager to discuss what occurred and gather any information from either parties regarding the application process. Rig Services will then probably have a discussion with our office to determine whether or not we believe that a violation occurred. If we find that a violation occurred or likely occurred, we have the same tools we've always had with enforcement of our housing ordinances, which is to say that we have the ability, or the department has the ability, to issue a notice of violation, notifying the owner or property manager that they believe a violation occurred and that they should come into compliance, and failure to come into compliance in the future may result in an administrative citation being issued. Also in this ordinance, it does waive the necessity of a violation notice, in which case if the department finds that there was a violation and determines that it was somewhat egregious, they can go straight to administrative citation in those cases. We also have, the department also has the ability to issue warning letters. They have the ability to issue a criminal complaint for any violation of a city ordinance. Of course, we have mostly gone away from filing criminal violations for our housing ordinances, but it is still a possibility. And lastly, the department does have the ability to take adverse license action if they find that there was a willful violation of the ordinance, which could occur possibly on the first violation, which would result in the issuance of a notice of noncompliance. In most cases, it would probably be after the second violation. If there was a second violation, the city could move to revocation or other adverse license actions, such as a settlement conference and placing conditions on a license. As part of that, the ordinance does require that owners, property managers keep records of the applications and denials and acceptances for a period of 2 years, so that those documents can be reviewed if there is a complaint filed. And with that, I will turn it back to Kelly.
Thanks, Lee. All right, so okay, so then the next slide. The next slide I wanted to go over with you is the cross-sector implementation committee work. Again, this team was mentioned prior, but it was a team that was set up in the ordinance specifically to look at project goals, to work with city staff to review project goals in the rollout of the ordinance, to give us feedback on the information that we were delivering, also to talk about best practices in other communities or in the industry, although Minneapolis is pretty much one of the first cities in the country to pass an ordinance on limited screening criteria. Also, the committee provided information on communication and outreach, especially how to engage renters and owners meaningfully. And finally, the committee's been working with staff on outreach materials and providing feedback and input on those on the website. We have a series of handouts that we'll be distributing. We have an instructional guide that goes into more detail for owners and renters on the ordinance, and then we'll be doing additional webinars in June and throughout the summer in order to keep people up to speed on ordinance implementation. And then just quickly to go over who was on the implementation committee, that again, it was cross-sector and it represented both housing industry leaders as well as legal and tenant advocacy organizations. So on the committee was Legal Aid, the Minnesota Multi-Housing Association, the National Association of Rental Property Managers, the Alliance for Metropolitan Stability, Homeline, the Realtors Association, Family Housing Fund, Housing Link, and the MCCD. It also was staffed by 5 city departments, including the City Attorney's Office, Regulatory Services, and our Planning and Economic Development team. So with that, I'm going to hand it back to Joe and Jennifer. Thank you.
Okay, thanks to Kelly and Lee. One of the things that that Jennifer and I struggle with, and many of you may as well, is we've been pretty deep in the weeds in this thing for several months, and even at times we struggle with setting our own policies for our companies. And so one of the things we want to do is maybe try to look at this from a different perspective, not so much just like walking through every piece of the ordinance, every page, every option. It can get pretty confusing. So whether you use this or not, it's another way to, I guess it's another way to look at it. It's a view from a practitioner standpoint. I'll walk you through a grid I'm going to share with you in just a moment on the screen. And then Jennifer will jump in and she'll add some of these I might have missed and kind of her own color. So I'm going to take off, see if I can share my screen. I'm going to take my camera off so you don't have to see me. Okay, all right, so here, and you'll have access to this when we're done if you choose to use it. It's pretty simple, but
Hey, Joe.
Yes.
Hey, Joe, I don't see your document anymore.
Oh. Okay. Now?
That's your webcam. Try the one below it. There you go.
Okay, sorry everyone. Okay, all right. So here's the diagram I thought could be helpful to go over. So this is the way I've thought about it when I try to get through this. So an application comes in, and rather than go through the whole ordinance and what option and what do I have to do for each of these, think about how we do now, which is we think about it by 4 really big categories. Now, this is nuanced. We got hundreds of people here that have everyone, it's like a fingerprint. Everyone's got their magic sauce for how to do this, but I think these are 4 categories we can agree on are pretty critical in general. So the first one, which is I think the simplest one, which is income. The application comes in. If your requirement, if you don't either have one or your requirement is something less than 3 times rent, as an example, 2 3/4 or 2.5, you have no issue here. You move on, you follow the blue arrow to credit. If you do require equal to or more than 3 times rent, then the biggest thing you need to do here in following the ordinance is you need to consider similar obligations met. That's my own words. It doesn't say that in the ordinance, but essentially that's what we believe the intent of this as a group is. If someone makes less than 3 times and they're able to show similar burden somewhere else and they were able to be successful, then you need to consider that as part of your evaluation criteria. My suspicion is that everyone kind of does this anyway. We do this. I think many of the peers that we've talked to over the past several months do the same thing, and it's something that now is probably part of the ordinance. And I think in practical matters, it really doesn't change. It doesn't change what we're doing, but that is now part of the ordinance. So whichever branch you go through, you're now moving into credit. Okay, so the second piece of this is your credit history. And my guidance here is that we now can't use credit score at all. That score is no longer being used, but you can use all the things that went into creating your credit score. And I provided some examples. Again, these are my examples, but this is my interpretation of it. You maybe would not want to include education or medical debt, but you would want to use all types of housing history, whether that's home ownership or rental, utility payments, credit cards. And then furthermore, consider the age, the number of occurrences, the amount of those occurrences, things like judgment, defaults, bankruptcies. Those are examples of things that I would use that historically go into creating the credit score, but I won't use the score, but I'm using all the data that will tell me that. And the one thing I've kind of learned is that a lot of these screening companies will be able to give you diagnostic tools on their site of your past applicants, and you can sort of get data on those applicants and compare them against credit scores and compare them against success or failures historically. So talk to your screening company, develop your own method, have a specific method, but you can still use all those components of creating the credit score. So now we move to the third function here, third part of the evaluation, which is rental history. And many people follow this guideline now, but if you have a eviction on your record that is 1 year old or 3 years old with a judgment, if your criteria, your guidelines are less restrictive than that, then you have no problem here. You follow the orange arrow into the criminal section. If you consider something more strict than that, then you need to consider supplemental data that's been submitted at the time of the application. So if, for example, your requirement is 5 years for eviction since a judgment, the ordinance says anything over 3 years of age you cannot use any longer. But if you use 5 years, you now immediately need to consider other data that's submitted. For example, the renter may have 4.5 years of excellent history. They may be able to show that they've got a letter of recommendation from that particular housing provider. They may be able to show that they've settled that completely and there's no debt. So these are things that we need to now consider. Again, I think many of us are already doing this now, but this puts it formally into an ordinance. So whichever path of the branch you go, now we go into the criminal piece. This one seems to get some of the most questions. The left side says you're following the inclusive guidelines, and those are very well detailed in the ordinance. Look through those. If you choose to follow those, and you're publishing that at the time of the application, you're sharing that with the applicant, and you have no issues. You follow those guidelines, and you move on to finalizing your screening and responding to the applicant. Same thing here is with rental. If you choose something that's more restrictive than those guidelines, for example, many people follow HUD's guidelines, which were issued a few years ago on criminal history. If you choose to follow that, you have to consider what other supplemental data was submitted by the applicant at the time of application. So again, no different rental. So I think I'll let Jennifer take over now and share additional color and thoughts. But I just think looking at this is a great way to share with your staff, your leasing agents, and it's a great way to go through these one by one and not be overwhelmed by the way this is written in an ordinance with 12 pages here. Jennifer, I'll let you add some color.
Hi, good morning, everyone. I just want to add a couple things. Number one, I do want to make sure it's stated that these ordinances are in effect on the criteria, even if you do not charge an application fee. So whether you charge an application fee or not, this is city ordinance. Secondly, I want to chat a little bit about documentation. For those of us that have been in the industry for a very long time, and we're operating through the financial crisis in 2009, 10, 11, we were changing criteria to keep our units full. And now, just like back then, we just want to document all of our changes. So come June 1st, as you have your new criteria, you're going to document the changes that you've made, what your criteria is. After working maybe with 6 months or any changes that you see as a company so that you can continue to keep your units filled and continue to be in compliance with city ordinance, always document the change if you change any of your criteria. Additionally, it is, as a reminder, city code and state law that the applicant must know what the criteria is before filling out an application. I think that the tool that Joe Abraham made is great. It outlines it very well, and I think it's just a great piece. That's all for my comments for now.
Okay, thanks, Jennifer. So I think, Aubrey, are you going to take back over and maybe have, hopefully you'll figure out how to give you back control. By the way, this will be available, so I think in the resources, and then I think Todd Liljenquist is going to moderate a Q&A, is that right? Have you got control?
Yeah, I will take over from here unless, Aubrey, you have something that you'd like to.
Todd, the only thing I want to add is in the handout section in the control panel of everyone's screen, you'll see there's 3 handouts. One is the overview technology, one is Kelly's and Lee's slides, and one is Joe's slides. You should be able to download those and print those for your reference from there.
Okay, we have a number of questions and plenty of time for them too. So the first question relates to deposits. And the question is, for deposits, can you charge pet deposits if the deposit is equal to 1 month's rent? How does the ordinance impact pet deposits?
Yeah, I can go first. Yeah, we believe that other deposits are permitted here. So whether that's something for a pet, sometimes people have key deposits, other deposits like that are outside of the norm. Now, if you start charging a full month of rent for a key deposit, I think that probably doesn't follow the intent here, and you might have, some explaining to do. But outside of that, those are sort of normal courses of doing business, and we believe that's allowed.
Yes,
I agree
we
with
would.
Joe.
Me too. This is Kelly.
Okay. Next question. If a person is denied from renting an apartment but feels like there may be a violation and decides to call 311 or report it to the city in some way, can the owner or manager rent to another prospect that qualifies for the apartment even though there's a potential dispute with the first applicant?
I'm going to jump in, and then Lee, you can answer. Yes, I believe the owner could go ahead and rent again, and the investigation of the potential violation would happen after the fact, but we would investigate. Lee?
Obviously we can't give you legal advice of what to do, but I mean, the way we anticipate it is that most of the complaints will come after a short period of time, and the property will probably be rented by somebody else. That's what we kind of anticipate. Whether, how you want to go about, if you deny somebody, if you want to wait, that's going to be your decision. But yeah, we anticipate that most of the complaints that come through are going to be kind of after the fact, and somebody else will be in the property at that point, but the investigation would still continue.
Okay. Am I exempt if I am an owner-occupied owner?
No, this applies to both owner-occupied and non-owner-occupied property.
Okay. Under the individualized assessment criteria, there are items listed for which a renter could provide supplemental information to be considered. And it has in quotes, considered is subjective. If the owner has reviewed such documentation and considered it and found it unacceptable, what safeguards does the owner have to make the refusal to the renter?
I missed the last part of that, the very last sentence.
What safeguards does the owner have to make the refusal to the renter? So they have, quote, considered the information and they deem it unacceptable, or it doesn't meet their criteria. What protections or what safeguards does the owner have in making and denying the applicant?
I don't know, Lee, do you want to answer that? Or I guess it's no different than you handle things today in terms of having safeguards, as you have criteria. And I know this is a little bit, there's some more ambiguous pieces here, but you're going to have to make that decision, keep good documentation of why you made one choice versus a different choice for someone that would have a different set of criteria, and keep that documentation available. Lee, do you want to add any more to that?
No, I agree. I mean, I think you obviously have to keep your documentation so that it can be reviewed, and then the applicant's going to get, what the criteria is ahead of time. So if for some reason, when you deny somebody, if your reasoning then doesn't jive with the criteria that were set up front, that can be an issue. But it's really going to be, are you consistent? Is it a reasonable denial, based on what your criteria is? That's what we're going to look at. Were you consistent with the criteria you listed ahead of time at the time of application with the reasons for the denial? And, is it consistent?
I just want to add, I think that also it's important to remember that's if you're doing an individualized assessment. So you'll have, if, for example, if you're going to require 3 times the rent, then you're also going to require what supplemental information is needed. And so, you know, like Lee said, you'll have that in writing if it doesn't match up, and then it's a denial, and that would be clear based on your criteria. But again, if you're using what the city is doing, you don't need it. You don't need, that's only if you are doing individualized assessment.
Okay. A question about resources and the materials that I think, Kelly, you may have mentioned. If you have a website where all the materials are available, do you have a citation or link yet, or are those still being developed and in the process?
So there's information on the web right now, and I can provide people that link. And then the materials that I talked about are still being developed. They should be ready within the next couple weeks for people. And those will also be posted on the web.
Okay. Do you happen to know the address off the top of your head where the current materials are?
Yeah, I think if you did www.minneapolismin.gov/renter protections, you would go to the webpage with the current information.
Okay, perfect. Thank you. Next question, can an income requirement still be used to deny rental?
Yes. Yeah. If you, I mean, kind of going back to that diagram, if your requirement is something less than 3 times and that follows the inclusive criteria, no problem. If you require 3 times or more, you can still do that. You can require 3.5 or 4 times. It's just that you need to be considering supplemental information. If you know you've got someone, which might happen today, where your requirement's 4 times rent, but you have someone that makes 3.5, and they've been able to show 10 years of history paying a similar burden of rent, then I would argue that I would guess you'd want them. I mean, we want customers, so my guess is that most people would accept them today. You just have to consider that data.
Okay. Next question, clarification. If we're accepting a tenant today, we can still charge a higher security deposit since the ordinance is still not in effect. I assume that is correct.
Correct.
Yes, that's correct. The ordinance does not go into effect until June 2020.
Okay. Question about effective date and enforcement. December 1st for owners of less than 15 units. I assume it's 15 units per building. We have 2 properties by 1 owner next to each other. The units combined together are 21. Otherwise, there's 1 building that's 10 and 1 building that is 11. So how would that be treated under the 15?
It's total units per owner. So if they own 2 buildings that have 8 and 8, they're at 16 units. So it would be effective June 1st. So it's total units per owner, not per building.
So, you know, and Todd, I'll maybe jump. We contemplated this, and I know as Lee's answering that, I know what a lot of people on here are thinking, which is, okay, but ownership groups are different, and oftentimes they're single asset entities. So you could have a person have 4 separate ownership entities, and each of them are 5 units, and they make up more than 20. And so we talked a lot about this. In the end, we said, well, either way, you're following this on December 1st. So I think technically the ownership groups are different. Each ownership group has less than 15, but what I would do is any building that we have that's under 15, we're starting to follow this on June 1. That's just my practice. I'm not suggesting that you can make your own, everyone can make their own decision, but I'm not going to start implementing it one way for some and one way for the other. But if you have 15 in total in common ownership, you know, might not be a bad idea to start this on June 1. I don't know how this would be tested or found and if it was challenged, but that's what I'd advise.
Okay. Is the burden on the applicant to provide the supplemental information at the time of application, or is the burden on the landlord to say, I'm considering rejecting you on criminal history. Do you have any supplemental information you wish me to consider?
I mean, I don't think the landlord or property manager is required to ask that. If the applicant does have that information, you know, they have to consider it. My guess is it would happen like like the question stated. Somebody, you know, the owner may say, you know, here's my criteria. I need to consider any supplemental information if it's, you know, different than the inclusive screening criteria, and they would, I mean, it seems natural that they would say, you know, do you have anything for me to review? I don't think they have to, but I mean, that's the way I would see it kind of happening.
Okay. This one is specifically for Joe. For the resource you walked us through, would you provide that document to potential applicants as a way to meet the requirement that applicants know the criteria before applying?
I hadn't, that's a good question. I don't know that I would. I suppose you could make something similar that's tailored more towards the applicant though, so you could give them kind of a better picture. It's difficult because what you're providing upfront, in my view, I want to be a little bit more detailed to answer some of these things. So maybe, I mean, I guess if you tailored it more towards the renter and changed some of the language and stuff, I suppose you could. I probably am not. I'm not planning on it. I'm planning to use this with my staff.
Okay. Does the ordinance allow applicants to sue owners for violating the statute? If yes, what exactly can owners be sued for? Are there money damages, for example?
The ordinance does provide, I'm trying to think of the actual wording.
Private
Yeah.
right of action.
Yes,
Yeah, it does
that was
provide
right. It does.
private right of action. You know, I can't say what that would be. I would not be representing any applicants or tenants. You know, they would have to consult with private attorneys to determine if they have an action to bring and how they would bring that.
I want to put everyone on a month-to-month tenancy with a 30-day notice. Any issues with month-to-month leases under the ordinance?
No.
No, I would say there is not. The ordinance doesn't speak to that.
Hey, Todd, sorry, a little unorthodox, but maybe just to go back to that last question, because that was a really easy and quick one. I don't know, Lee, if you've given kind of how you envision this going, and Kelly coming through 301 and each of the steps and how that might go, your conversations. Do you want to go over that, or do you want to just let that roll through? I'm sure there'll be a question about it, but it might not be a bad idea to head off some of those. I'm sure there'll be a lot of questions about the enforcement and how the enforcement process is going to go.
Well, I think Lee covered it, but I can in his description. But I mean, how we anticipate, because we haven't had a complaint, the ordinance isn't in effect. So, but I anticipate we would do it similar to other situations where if we get a complaint, we follow up. We'll talk to the applicant first or the renter to get information as to why they believe the ordinance was violated. We'll then also talk to the owner to gather information from them about what screening criteria they used, and the documentation that they have that shows what information they used and what they considered and their rationale for denying the applicant. And then we'll take that and talk to the city attorney's office and make a determination as to whether or not there was an infraction of the ordinance, and again determine sort of the next steps for enforcement, whether it's an advisory letter or a warning or a actual citation or more. Lee?
Yep, you summed it up. You know, at that point, I know when the ordinance and when we first met with the implementation team, there was some talk about, you know, due process, and even when the ordinance was being written. Once we do, you know, the department does issue a citation or there, you have the ability just like to challenge that citation, just like you do with, you know, not fixing your broken windows. You know, you have an opportunity to appeal that and go to an administrative hearing officer and have a hearing about whether or not you violated the ordinance. So, you know, the same procedures would apply in challenging a citation as with any other violation that's issued on property-related violations. So.
Yeah, thanks for clarifying. One of the reasons I brought it up, and we've talked, I mean, Lee, you and I had side conversations, just selfishly trying to understand setting my own guidelines. And that's why we thought it was so important for Kelly and Lee to both be on this, for them, people to see, hey, they're here to try to help us navigate through this. They aren't policymakers. They didn't pass the policy, but they're here to administer. And so if you're knowingly and you're just ignoring these policies and you're doing some of these things intentional, I think you're going to have a problem on your hands. But well-intentioned people trying to follow this, trying to follow the intent of this, you should see that Kelly and Lee are, you know, they're not, you know, it's not this one big monster of a city with big pointy teeth. They're here to try to help us navigate it as well. And so I think it's important. I'm glad that they're here, regardless of how you might feel about the ordinance. It's nice that they're here to help us navigate it. Lee's not sitting there waiting for a chance to revoke a license. So I just thought it was important to, you know, review that again. So thanks, Todd.
Yeah, thank you. For some renters, we are able to approve them with condition of a cosigner or last month's full rent. If they choose last month's rent, will we be required to allow them to make payments over 3 months? Or does that only apply if we are requiring them to pay a last month's rent without choice?
It's the same. If you're requiring last month's rent, then its damage deposit is paid in 3 equal installments over the first 3 months.
Right.
It doesn't prevent them from paying it early if they want to, but that's the ordinance.
Here's a question on security deposit. If a unit's rent is $1,500 for rent and $100 for garage, is the security deposit limit $1,500 or $1,600?
My view on that is $1,500, because if you choose not to have the garage, you know, the rent is, that's my view, but.
I would agree, Lee. That would be mine as well.
Stump the panel here. I would actually say that you could charge a separate lease for the garage for $100 if you wanted to, but I mean, I don't know if that's normal practice or not, because you got an opener and things related to the garage. I don't know, Jennifer, you want to break the?
I agree. We have a separate garage lease and we have separate deposit on openers.
So we answered that one really well.
Yeah. If we charge 1 month rent for security deposit normally, what is the most we can charge for an additional security deposit? And I think you've covered that. I don't know if anyone has anything additional to add. Is there a standardized or suggested expectation of reporting or showing changes in your criteria? So let's say you change your criteria over the course of operating the property. Do you need to standardize that or report that or show that in a certain way?
Not to the city. I mean, I think Jennifer covered that you want to document your changes. So if later on somebody says, well, at this point you were taking this and then it changed, you have the documentation that you changed it. From the ordinance perspective, you're really looking at, you know, the criteria has to be provided to the applicant at the time of application. So if it changed from 1 week to the next, then, the new criteria, somebody applying that week will get a copy of the new criteria. As Jennifer said, you should have in your records that it changed on this date and you have that documentation. So if somebody comes back and say, well, the applicant last week got this and now I'm getting, you're requiring this, you'll have the documentation that show that it changed.
Yeah, I'm pretty passionate about documentation. So you do want to document for a couple of reasons. Number one, record keeping is in the ordinance. Secondly, if you're changing criteria from 1 week to the next, what if those two applicants know each other and they're like, hey, what happened here? You want to have clear documentation of exactly what your change was. I would even go further on why you made the change. And then keep that in your records. The other thing I just want to remind you is if you're making a change in criteria, make sure it's everywhere. Make sure it's on your online listings. Make sure that it's in your documentation. If you have your criteria on your website, cover all your bases. Criteria on the website and in the ad that are different is going to cause a problem.
Here's a question sort of dovetailing off of that about disclosure and transparency. So this is a small owner, has less than 15 units. Do I disclose to tenants prior to application that I will be using the individualized assessment?
Yeah, I think, you have to provide the applicant with the criteria. And if you're going to use individualized assessment, you would state that and what the criteria is in your assessment.
Right, because even in the individualized assessment, you need to have some specific criteria. It's just that in the individualized assessment, it can be more strict than what's in the inclusive screening, but it still needs to be clear and available to renters.
Yeah, no,
So-
just to clear, go ahead, Jen.
Oh, I was just going to say, and correct me if I'm doing it wrong. So Guardian has had the opportunity to write up what our criteria will be June 1st. We did not call out the word individualized assessment. We just were very clear on what the criteria is and what they would need. But
Yeah,
we didn't call out individualized assessment.
Yeah, I think that's fine.
Agree. Yeah, I just think it's important that that there are going to be portions of this that, so it hasn't come up yet, maybe it will, maybe it won't, but a lot of people have asked me about sort of a hybrid where can I do a combination, and that's sort of where, going back to that grid I put up, I mean, you can do some combination. It essentially though becomes an individualized assessment, right? You just happen to be using some of the criteria that are part of inclusive, and you can certainly do that, and I think your bases are covered. If you're following one portion of that, it doesn't extend to the other portion. So you might, to me, that inclusive or the individualized assessment applies a little bit more to criminal and your rental history, your housing history. So I do think that you're going to want to seek legal counsel to make sure that you reference, as Jen said she did, whether you use the words individualized assessment or not. I think you want to acknowledge when you either hand them that criteria or on your website or both, that what you're doing in the city of Minneapolis and that you are doing this assessment.
And here's Joe, to that point, someone asked, when using the applicant screening options, are they interchangeable, or once you use one option, that is what you use for every application? So I assume that's the city criteria versus the individualized assessment. Can you use it interchangeably for different areas? So credit versus criminal.
Yeah, I mean, others may have other things. That's a dangerous question because you can't use it different for different people. But but obviously, so within your buildings, whatever but if you want to use parts of it, that's kind of, again, that diagram. I think you can use, if you're meeting some of these inclusive criteria, fine, you move on, you move from one to the next block, and then you're still technically, I guess, in that option 2, which is individualized assessment. But if you're not requiring something that's more stringent than what the city was in their inclusive, you got nothing to worry about. And I think Lee and Kelly would nod in agreement on that. So I think that's, I don't know if that answers, hopefully that answers the question, but you have to be careful. You're not deciding who you're going to do individualized assessment with and who you're going to do inclusive one with. That's dangerous.
Right. What about screening agencies? Is there any indication that screening agencies are providing different information now? For example, we need date of sentencing, not date of filing of charges, date of settlement for evictions, not date of filing of the eviction actions. What about the screening agencies?
Jennifer, you want to take that call?
Sure. I think that you do need to be working with your screening company directly. People are getting information, whether they're finding it on their own or working with a screening company. And although they're very similar in best practices, I think the information you get, from my understanding, is a little bit different with each company. So please work directly. We did meet with the screening companies as part of our implementation process. The screening companies have indicated they're reaching out to their individual clients. They also indicated that they would be putting information on their website as well as doing emails. So please connect directly. There's not a standard that we can just quote today's webinar or that we can put out there.
But I do think, like, excuse
Oh.
me, like Jennifer said, just checking with your screening criteria to make sure they're aware of the ordinance, that they have made adjustments in how they're providing information, etc.
Okay. Question about subsidized properties. How does this affect the HUD Section 202, Section 8 affordable projects, tax credit properties, or even voucher properties? We have mandates to adhere to on federal and state regulations. So how does this change the way we do business?
Well, in the ordinance, there is one section, and I can't speak to the very specific programs that were mentioned, but there is a provision in the ordinance that specifically states if there is a funding, federal or state funding provision that that preempts or that takes precedence over the local ordinance. But I don't know the specifics of the funding requirements, so I can't speak to those directly, but there is a section in the ordinance that does consider that. Lee?
And
So
that's
it's section
subsection
2F.
F.
Yeah,
Pardon?
2F, it says exception whenever local, state, or federal funding or loan requirements for tenant screening conflict with any portion of this section, and it identifies the code. The funding or loan requirements will take precedence over only those portions in conflict. So I believe whatever source it is, if it's federal funding and it requires something, that does take precedent over this ordinance, just for that portion. Lee, do you agree? I mean, does that make sense?
Yeah.
Do we have to participate in advocate programs like GRH? I don't believe this changes any sort of requirements related to that.
No.
Do we have to accept co-signers?
I don't think you have to.
The notice of rights described under the security deposit section, there's a question about when that will be made available. It's the form and manner approved by the city or provided by the city. I assume that will be available, Kelly, as you mentioned, in the next couple weeks as well.
Yes, it will
Okay.
be.
And
There's also a place, if you go to the website, a place for text alerts. So we encourage people to sign up for the text alerts, and then when new things are available on the website, we'll do a text alert to people.
so, Lee, I know when we did our practice round on this, you spoke a little bit to this, but I'm getting the sense by some of these questions, there's a little bit of anxiety that, you know, the ordinance is coming effective in a couple weeks or a few weeks, and some of these materials won't be available. People feel like they can't comply, and is the city going to come down hard on them, and they don't even have the resources or the information available. So I know we have talked about complaint based, but maybe you can help reassure folks a little bit.
Yeah, I mean, and especially considering the age we're in right now with everything that's going on, and unless there's really, it's going to be based on our, the department's investigation. If they find somebody that just blatantly is violating these, I mean, then our enforcement's going to be a little stronger. But everybody anticipates that it's a learning process, and we're going to take that into account. We're obviously going to enforce it if we find there's willful violation, that people knew about it and just blatantly ignored what's in the ordinance. But yeah, we don't anticipate coming down, oh, we're revoking rental licenses, July 1st because we found a violation.
Right.
That's not what we're anticipating. We're anticipating, and as Joe said at the beginning, the implementation team is going to be meeting throughout the summer, I would guess into the fall, to discuss stuff that's happening and that we're finding out. So it's going to be an ongoing process. And, not to say we're not going to enforce, but I think, we'll take into account what information we find out when we do the investigation. And as we said, more blatant and just obvious flaunting of the ordinances are going to get, a little more stricter punishment or enforcement than somebody who's, made a pretty good effort at complying, but didn't understand some of the nuances, is going to be treated differently.
Okay, thank you for that. If a tenant has income less than our requirement, say 2.5 times, but receives a subsidy, can you speak to how we should consider the subsidy payment?
So, I mean, income is income, really. I think I guess I think about that two different ways. If they're getting some other form of income, I think you have to include that as all of their income. But to the extent you're requiring that their portion of the rent due is 3 times or 2.5 times, then I think you can follow that same model. At least I don't think that's any different than before, really. If you stated before it was 3 times and they made 2.5 times, if their portion of $1,000 rent is $600, then you'd want to make sure that and if your requirement was 3 times, then you'd want to require $1,800. I don't think that's changed in any way, unless I'm misunderstanding the question.
No, I think that is the question. Here's a question about the 15-unit bar. If I have a mix of residential and commercial units, are the commercial units, do they count in consideration of the 15 units? I would assume not.
No.
I would say no, they don't. It's residential units that we're looking for. So if you own a mixed-use building with commercial below and apartments above, and you don't total 15, then no, it's not. It doesn't go into effect for you till December.
There's a question about an alleged violation. So say there's an alleged violation. Do we need to get permission from all applicants to share their application file with the city should a review be required? Otherwise, isn't their application private information?
Lee, do you want to answer that, or how do you?
I haven't even contemplated that. That's something we'd have to look at.
Yep. And I'm assuming if they made a complaint, they're willing to share all information that's needed for us to make a solid founding or.
I think the question might relate to the other applicants. So if it's comparing how one applicant was treated, comparing it to someone else, and I would assume it's. Go ahead, Joe.
The only thing I was going to say is no different than else. You'd probably have data that's scrubbed. I mean, you wouldn't have their name, their birth date, their personal information. It would just, you'd have here's the criteria that we used. This applicant was approved, this one was, and here's kind of a consistency. I suspect most people were doing that anyway because they want to comply and make sure that they have some consistency here. The challenge that everyone's struggling with, or we wouldn't be on this webinar, I wouldn't be talking about this and spending so much time in, is that it really is like a fingerprint. No one has an exact same history, and so judging and making these things, comparing one person to the other and why you approve one and the other is very difficult. I mean, that's why people use things like credit score in the past, like it or not, whether we all agreed with it or not. It was a number you could point to and say, you hit this number, you're in, you don't, you're out. So you just have to spend a little bit more energy and look at this in a more nuanced way.
How about a question on rental history? So if a tenant was evicted more than 3 years ago, but still has a balance owed to the landlord, can that balance owed still be considered? And a corollary with that, if someone was evicted and it's outside of the 3-year requirement and there's a bad rental reference related to that eviction from a prior landlord. So two things, balance owed based on something that is past the 3-year requirement and or negative reference from a prior landlord.
So we talked about this one before. Lee and I think we were all in agreement on it, which is that those are separate. So the eviction criteria is the eviction criteria. If it's older than 3 years and it's a judgment, or it's older than 1 year without a judgment, you can't use that unless you're going through the individual assessment. You're considering supplemental data. But the amount owed is a different thing. That has more to do with their credit history, and you can use that as part of understanding credit history because they aren't necessarily always linked. One is possession of an apartment. It has nothing to do with financial. Now, you may have evicted them because of financial reasons, but that isn't the same thing as a bad rental reference. You could have someone that actually had an eviction that gets a good rental reference, that they ran into some problem and then they were able to work themselves way out of it. And I've got plenty of people, and I think many of us do, that had something occur. I mean, look at what we're dealing with right now. So I think those are independent.
Yeah, I think we had that same question when we did the trial run last week. And yeah, I agree with you, Joe, that if you look at the judgment as part of the eviction as, bad credit or, a judgment, you're not using the eviction, you're using the non-payment portion of it, and that's okay. And the same with bad rent, reference. If, it may get a little tricky if the only thing about the bad reference is I evicted them. If the reference, talk about other things like, they damaged the property, I had to go in there and fix it every other month. They were late, late payments a lot, and, other things, that all goes into the reference and not necessarily just looking at the eviction.
And that goes both a two-way street too. So if you choose to be more restrictive than the inclusive criteria, and someone does have an eviction. So let's say for example, it's 5 years ago and it was a judgment, and I'm sorry, your criteria is 5 years. This person that applies had an eviction 4 years ago, but they paid off, they stayed in the apartment, they settled all their debts, they don't have anything. I think you'd have to consider that as supplemental data when you look at their rental history, and there wouldn't necessarily be anything negative on their credit history as well. So I think it goes both ways.
Are we allowed to go over specific information with a potential applicant that is on their credit report?
You mean to get more information about what's behind this information?
I think that's what it means. Yeah, I think asking questions about what is on their credit report, and that might get toward the individualized assessment prong.
Yeah, I think that's information, because you can't use the credit score, but you can use information in the credit report that is applicable to their ability to pay. So if that's discussions you can have with, they're able to have with you, I think that's information regarding their ability to pay. I think it's something you can discuss with them.
I think I know the answer to this one. Will the city or another agency be conducting audits of the screening compliance? And I think, Leah, you had said it's a complaint-based process at this point.
I hate to speak for Kelly, but I would guess her department doesn't have the manpower and ability to go and do audit checks of all the landlords and the rental units in the city. So yeah, I mean, it's going to be a complaint-based. We just don't have the ability to do otherwise. Is that correct, Kelly?
Yeah, I would say for sure at this time it's complaint based, you know, and like Lee said, we're, but I, you know, without projecting anything, I guess I wouldn't rule it out, but I just, there's no intention or plan for that at all right now, and we don't have anything else where we do an audit on the compliance, so I can't really speak to whether that would ever be a situation in the future, but for now, like all of our, or like many of our ordinances, similar ordinances, it's a complaint based.
Can each property under one owner choose inclusive or individual assessment, or does the owner have to have the same screening at each site? So Joe, you had mentioned this before, the individualized assessment portfolio wide, or can each property approach it differently?
I believe each property can. I don't know that you'd want to do this, but I can't think of a reason, or I haven't read anything in there that tells me that you couldn't have a different set of criteria for each ownership group. I don't know, Kelly, do you look like you
Are you talking about location around the city? Again, I
yes,
can't do legal advice at all, but just be careful, you know, I mean, just be conscientious of how you're applying it. Either, you know, building to building, and that's not unintentionally screening out for other reasons.
Guardian manages for different ownership groups, and you know, staying within, of course, city compliance 100% in the various cities. We do have different criteria for different buildings or ownership groups, and we sought counsel on that, so you'd want to seek your own advice from your attorney. But again, we have everything documented and we stay compliant within city ordinances.
Are non-refundable administrative fees impacted by the ordinance?
like an upfront pet fee or something like that, or
right, a non-refundable.
No, those aren't. I don't see those as restricted in any way.
No.
A question about limits on rent increases, and I don't think the ordinance addresses that at all.
No.
Nope.
Can we still get rental verifications under this ordinance, which I assume means other landlord references, and that is accurate?
Yes.
Yes, you may.
Is the city going to take this ordinance into account when tiering multifamily buildings, especially when associated with conduct on premises and criminal activity?
So there's been no discussion or decision about how this violation of this ordinance might impact a tier. So I can't address that at this point.
Okay.
And the tiering system is actually being evaluated right now for making sure that it's the right, that the tool is being used appropriately, and that the city is looking at ways to make sure that the tier score itself is reflective of condition of the property as well as other things. So.
Okay, a question for Jennifer and Joe, and feel free to answer or not answer, but a question about whether or not you're considering using the individualized assessment, or if you will just do the inclusive criteria.
I can go first. Guardian is doing, overall, we're doing the individualized assessment. However, like the income portion fits within the city requirements. And then we're changing, but we have some criteria under credit that we're doing. So ours is individualized assessment, but for example, under the income portion, it actually fits in with city ordinance.
Yeah, I mean, I think I'm probably doing more what you saw on the diagram, which is part of why I did it. I think more of a hybrid version where, like the income piece, I don't know, we'll probably continue to require, I think our requirement is 3 times, but we have that now, and we have someone that makes less and they're able to show they can handle that burden, we're accepting them. I mean, I want as many customers as I can get, so that can meet the obligation. So to the extent we have data on this, then we're going to accept those criteria, but there are portions that will go through individualized assessment.
Okay, and then a follow-up on that, this is a separate question, but do you then spell out the 4 items in the individualized assessment, nature and severity, number and type of incidents, etc.?
I don't know if I can answer. I haven't gotten to that point yet. That's a trickier one to answer. I think that people need to decide that best with their counsel. That it feels a little bit like I'm giving you legal advice, and I don't feel like I can give you a good answer to that. I'm sorry.
Fair enough. Can you use a credit score if the owner also allows an individualized assessment on credit? So I think the reading into the question, what it is that is the initial item to determine, and then you would move on to the individualized assessment portion.
So I think if they said they wanted to use credit score, then the score would be stricter than the inclusive screening criteria. So they would have to use the individualized assessment. And in that situation, then the renter applicant would be able to offer information into the details of that credit history and credit score that could augment or justify in their favor of why that information is not appropriate to determine their fitness as a renter.
I'm interpreting it that it was clear we couldn't use credit score. Joe, are you looking?
Okay, sorry.
Yeah, I know that I've heard a lot of different opinions on this one, as people know that we're involved and I'm involved and deep in the weeds in this one, and I haven't. And this, to me, this is one of the areas that's a little bit more ambiguous.
Lee, what do you think?
Yeah.
You know, obviously the inclusive screening criteria does not allow credit score. I mean, I think, you know, obviously if it's an individualized assessment, it's more to the individual. I don't think it totally, obviously we'd rather not have owners use a credit score, but if they choose to, I mean, like you said, Kelly, that's less restrict or more restrictive. They would have to take into a lot more into account, but I think it'd be more of a red flag that you're denying somebody just solely on the score. So that's kind of how I see it.
So 2A is the section, and Jen, one of the reasons I've heard people say that they think they can still use it, I'll read it, it's just a sentence long. It says credit score by itself, although this is what's restricted. Credit score by itself, although information within a report directly relevant to a fitness of tenant, can be relied upon by a landlord. So I think that's why I think you're right. What the intent was that you aren't using it, but I think this leaves it a little bit kind of open-ended here.
And Kelly, I wasn't calling you out. I just wanted you to know that there are different interpretations of that.
Yes, and I agree. Thank you. Again, we haven't gone live, and there are some areas of the ordinance that will require sort of clarification as we move forward as well.
I'll try and squeeze in a couple more real quick. gross misdemeanors. How are gross misdemeanors treated?
They would fall in the misdemeanor category.
If a prior landlord does not respond to a rental request, is that insufficient rental history and thus can't be considered as a basis to deny the application?
Can you repeat the question?
So if you reach out to a prior landlord and they do not respond, is that under the ordinance considered quote, insufficient rental history and thus can't be considered as a basis to deny the application?
It's no different than what you do today when you don't get a reference. What do you do today? I mean, I think about that as neutral or better. And I guess if you're not getting a response, that's the definition of neutral. You don't have any information.
Yeah, and the ordinance specifically says insufficient rental history unless the applicant in bad faith withholds rental history information that it might otherwise form a basis of denial.
Right.
So interesting question. Well, I think our time has come up, so I'll hand it back to Aubrey.
Thank you, Todd. And thank you very much to our panel today. A lot of really great information, and really thank you for taking the time today. I think this is really helpful and obviously a big need for our members. Again, we'll be uploading this onto our YouTube channel as soon as we can. I also want to specifically thank Joe. He spent a lot of time helping put this together, asking our panel to participate, and really helping frame this so we can have a great question and answer session. So thanks again, Joe.
Sure. One other thing, Aubrey. Sorry.
Oh, yeah, go ahead.
One thing I want to add, I meant to squeeze in there, is that we're planning to do, we were going to do more than one of these, but then we thought, well, that was when it was in person, and we just picked one date for this webinar, but we intend to come back a couple months into this because I think we're going to learn a lot about implementation. We're all going to get a lot smarter on this. So our intent is the four of us to come back, I don't know, it could be July, August timeframe, and have another one where we'll have a whole other set of questions and answers and maybe have some decisions on best practice, because the market will figure this out, I think. And so I just wanted to add that. So sorry to interrupt you.
No problem. Thanks, Joe. I think that's a good point. So yeah, we'll watch your email for that. We'll be sending that out later on. I also want to thank our sponsors yet again, Assured Security, Cozen O'Connor, Fox Trolls Agency, and First Select Property Management. We're very grateful to them and thank them for their partnership in helping us offer this free webinar today. I also want to thank all of you who have taken the time to attend, and thanks for supporting MHA programs. Our website, our education calendar is linked here on the screen, and you should be able to go there and find all the different upcoming training opportunities. We have some additional webinars coming up related to new best practices, bits and pieces that we have learned that our property managers and maintenance professionals have learned from COVID-19 that they plan to implement and keep in the future going forward. So that might be a really interesting to you. You can find those and register for those on our website, which is linked here. So thanks everyone for attending. Thanks again to our speakers. Thanks to Todd for moderating our question and answer, and have a great rest of your day.
Bye.
Bye, thank you.
Bye, thank you.